Justice Marshall Rothstein to our congregation.
Just stand in the middle here?
Yeah.
Okay. Well, thank you, Rabbi, for letting me off the hook about Jewish law and providing your explanation. And thank you for your generous invitation and for your warm welcome to me. But I have to tell you that your sentiments are not universally held. One day when I was still at the Supreme Court, I went to the office. My wife Sheila had asked me to remove the bed linen that day, which I thought I had done before I left. Email, Sheila Rothstein to Justice Rothstein, 10:53 a.m. I told you to remove all the linen, including the blanket cover. You did not listen to my instructions and only did half a job. I hope you do your legal opinions better than remove linen from a bed. When you get home, you will make the bed all by yourself. I'm always grateful that Sheila isn't the one to introduce me at these kinds of events. Well, some things haven't changed since I left the Supreme Court. I got coffee at Starbucks on the way to the office in Ottawa, and I still do in Vancouver, in addition to having coffee before I leave in the morning. Sheila's quite deaf and has difficulty on the phone, so we almost always communicate by email. Email, Sheila Rothstein to Justice Rothstein. Get fruit. Justice Rothstein to Sheila Rothstein. What fruit? Sheila Rothstein to Justice Rothstein. Berries, grapes, and nectars. Justice Rothstein to Sheila Rothstein. Nectars are out of season and not available, and grapes are expensive, but I'll get them. Berries are too expensive. Sheila Rothstein to Justice Rothstein. If you didn't waste money at Starbucks every day, you would be able to afford berries. One night we were going to a court dinner. Email, Justice Rothstein to Sheila Rothstein. Look in my closet and confirm that my tuxedo shirt is there. Sheila Rothstein to Justice Rothstein. Is it black tie tonight? Justice Rothstein to Sheila Rothstein. Yes, it's black tie. Sheila Rothstein to Justice Rothstein. Thanks for telling me. Justice Rothstein to Sheila Rothstein. What's the problem? Sheila Rothstein to Justice Rothstein. You have to let me know ahead of time so I'll plan what to wear. Were you planning on telling me at 6:30 tonight? Justice Rothstein to Sheila Rothstein. I didn't think it was a problem. You know that all dinners at the court are formal, whether black tie or not. I didn't think it made any difference. Sheila Rothstein to Justice Rothstein. I did not know all dinners were formal. However, I have a new dress to wear. Justice Rothstein to Sheila Rothstein. Fine. I trust it's a conservative dress. Sheila Rothstein to Justice Rothstein. It's a dress that I chose and like. The label does not say NDP, liberal, or conservative. I haven't been able to tell Sheila what to wear for the last 50 years. I don't know why I ventured into that territory that time. Well, by law, a judge must retire in Canada when they reach the age of 75. So my retirement from the Supreme Court impels me to tell you the story of the 75-year-old fisherman. This 75-year-old fisherman was out fishing one day, and he was in his boat, and he suddenly heard a voice. And the voice said, "Pick me up." And he looked down, and he saw a frog. And he looked at the frog, and he said, "Are you talking to me?" And the frog said, "Yes, pick me up." So he picked it up, and the frog said, "Kiss me, and I'll become the most beautiful woman in the world, and I'll become your bride, and all your friends and acquaintances will be jealous." And the fisherman thought for a moment, and then he put the frog in his pocket. And the frog said, "Are you crazy? Didn't you hear me? I said, kiss me, and I'll become the most beautiful woman in the world, and I'll marry you." And the fisherman said, "No," he said, "my age, I'd prefer a talking frog." Well, the rabbi first contacted me about this speaking engagement in early August of this year, as he told you. As always, I'm flattered by such invitations and readily accept when I can. However, as I read down his email, the rabbi informed me that my topic for the evening was to be forgiveness and the law. Well, my initial reaction was to think this must be a mistake. After all, forgiveness and the law are virtually oxymoronic. Laws are rules. You commit a crime and you're punished. You enter into a contract and you are bound by what you agree to. You harm someone and you have to pay the damages for the loss that was sustained. Where does forgiveness enter the law? Forgiveness, I thought, is the province of religion. And as the rabbi explained, it is. Well, I'll take a tiptoe into religion for just a moment. I thought I knew on Yom Kippur that we have communal confession. Al chet shechatanu lefanecha, for the sins which we have committed before thee. We pray, Avinu Malkeinu, Kadvenu, B'Sefer, Slicha, Umechila. Our Father, our King, inscribe us in the book of forgiveness and absolution. And we ask God to forgive us and to pardon us and to give us atonement. So in our religious text, we know about forgiveness. Of course, other religions also have forgiveness rituals. There's the story of the priest that was called away for an emergency. Not wanting to leave the confessional unattended, he called his rabbi friend from across the street and asked him to cover for him. Rabbi told him he wouldn't know what to say, but the priest told him to come over and he'd stay with him for a short time and show him what to do. The rabbi came over and he and the priest went into the confessional. After a few minutes, a woman enters and says, Claire, your kid is too young to understand what I'm going to be saying, so don't worry. After a few minutes, the woman enters and says, bless me, Father, for I have sinned. And the priest asks, what is your sin? And the woman says, I committed adultery. The priest asks, how many times? The woman said, 3 times. The priest says, say 3 Hail Marys, put $5 in the collection box, and you will be forgiven. A few minutes later, a man enters the confessional. He says, bless me, Father, for I have sinned. And the priest says, what did you do? And the man says, I committed adultery. The priest says, how many times? The man says, 3 times. The priest says, say 3 Hail Marys, put $5 in the collection box, and you'll be forgiven. The rabbi tells the priest that he thinks he's got it, so the priest leaves. A few minutes later, another woman enters and says, bless me, Father, for I have sinned. The rabbi says, what did you do? The woman says, I committed adultery. The rabbi says, how many times? The woman said, once. The rabbi says, put $5 in the collection box and go and do it 2 more times. It's 3 for $5. Not sure I should be talking this way in a synagogue. Well, the rabbi didn't invite me to tell stories and jokes or to talk about religion, so I'll get serious and I'll speak about forgiveness in the law. And I'll put forward 2 concepts. 1, forgiveness in the context of the law, recognizing the human condition and taking account of it. And 2, justification. You do something wrong, but the law forgives you. And I think these concepts will be quite familiar to you. So first, recognizing the human condition in criminal law. A crime is committed, and unless the law prescribes a mandatory minimum sentence, the judge will have discretion to take into account the human condition, provocation, racial slurs, mental illness, youth. You assault someone, you even kill them. The law doesn't let you go, but it understands, and so a sanction or penalty may be ameliorated. The law is recognizing the human condition, and when it does, we see forgiveness in the form of ameliorating punishment that might otherwise be imposed. On the other hand, there are instances where the law will not ameliorate or forgive. For murder, the sentence is imprisonment for life. First-degree murder is generally murder that is planned and deliberate, or if the victim is a police officer or a jail guard. A conviction for first-degree murder carries a minimum jail sentence of 25 years. After 25 years, you may get out on parole for good behavior, but if you're not paroled, you're in jail for life. Second-degree murder carries a minimum sentence of 10 years. But murder can be reduced to manslaughter, for which there's only a 4-year minimum sentence if a firearm is involved, and no minimum penalty if no firearm is involved. So, for example, murder can be reduced to manslaughter by reason of provocation. Provocation is a wrongful act or insult of such nature as to deprive the ordinary person of the power of self-control if the person acts on the sudden and before there is time for his passion to cool. So instead of a minimum sentence of 10 years for second-degree murder, a lesser sentence is available to take account of the fact that what you did was wrong, but there was a human reason for why you did it. Sometimes the judicial system may be seen as too forgiving. Some of you will have heard about the case of Brock Turner earlier this year. He was the star athlete and student at Stanford University who raped a girl after they had been drinking and she was unconscious. It occurred outside behind a dumpster. He was observed and caught. The sentence for rape in California is 14 years. In a pre-sentence interview, Turner expressed remorse and empathy for the victim. He had no criminal history. He was only 20 years old and on a swimming scholarship at Stanford. The victim impact statement described the negative effects of the rape that it had on the victim. The prosecutor said that Turner failed to take responsibility and to show remorse. With all that, the judge, his name was Aaron Persky, sentenced Turner to 6 months. He was released after 3 months on parole. There was enormous public outcry that the sentence was too lenient. The California legislature has since passed a mandatory minimum sentence for this type of rape and is now up to the governor to decide whether to sign it or not. Well, this case raises some interesting questions. Can the law be too forgiving? Is public reaction a proper test for how far forgiveness should go? Well, now I'll turn to the other aspect of forgiveness in criminal law, and that is where the law entirely forgives an illegally wrongful act. The criminal code provides that no person under the age of 12 years shall be convicted of a criminal offense. The rationale is that a child under 12 does not have the capacity to appreciate the nature and wrongfulness of what he or she did. The rule is absolute. So whether the child had the capacity to understand or not, it doesn't matter. If he was shoplifting or if he committed murder, the law forgives him. At one time, children between the ages of 7 and 14 were presumed not to appreciate the wrongfulness of what they had done, but the prosecution could overcome that presumption by demonstrating that the child did understand what he was doing and that it was wrong. So forgiveness was based on the facts of the individual case. But now the rule in Canada is absolute. Absolute forgiveness if the child is under 12. Is that the right age? It varies in different countries, from 7 to 15 years. Should the rule be absolute? Should there be a difference depending upon the severity of the crime that was committed? These are difficult questions, perhaps better left for the rabbi. Not putting on the spot, Rabbi.
I already have my sermon topic.
Okay. A couple of other examples of justification or excuses for committing a criminal offense. First, self-defense. Self-defense essentially means that in certain circumstances, it may be lawful to meet force with force. So the attacker is the author of his own misfortune. The law says that self-defense is a legitimate attempt to stop the threats or an assault by meeting force with force. I won't get into the detail, but as a general rule, self-defense is justified if the force used is no more than necessary to defend yourself. And so if you believe you will be killed or seriously harmed from the violence of another person, you can take action to defend yourself, and that will be legal. You will not be considered to have committed a crime. What you did was justified, so even though you assaulted another person or even killed him, you did no more than defend yourself, and your actions were justified. The law forgives what would otherwise be a crime. Duress. This is different than self-defense. Duress arises when you are threatened unless you commit a crime. The threat must be explicit and directed at you or a third party. There can be no safe avenue of escape. There must be a close temporal connection between the threat and the harm threatened. And the harm threatened must be proportional to the harm to be caused to you. So this definition of duress is quite narrow. Why is the excuse of duress available? Because only voluntary conduct should attract the penalty of criminal liability. If you are being threatened by death or bodily harm, if you don't commit a crime, you are not considered to be acting of your own free will. So the law will forgive you. Although you are morally blameworthy for committing a crime, under duress you acted in a morally involuntary manner. The act remains wrong, but you won't be punished where you had no realistic choice. So the law forgives you. One more criminal law example, and that is on the subject of consent. As you might imagine, the defense of consent often arises in sexual offenses. And I am looking around, I'm not seeing any young kids in the audience that will understand. If an accused person can demonstrate that he honestly believed that he was engaging in sexual activity with the consent of another person, and that he took reasonable steps to verify that she was consenting, that would be an absolute defense. But there are very strict rules in the criminal code that limit the availability of that defense. A few years ago, we had a case in the Supreme Court called J.A. In that case, a couple had been living in a long-term relationship. They had engaged in sexual relations. The male choked the female, and she became unconscious. The female testified that she had consented to the choking and that she and her partner had experimented with erotic asphyxiation and that she had lost consciousness before. When she awoke this time, her hands were tied behind her and her partner was inserting a sexual device into her. 2 months later, she made a complaint to the police that while she had consented to the choking, she hadn't consented to the sexual activity that had followed. Apparently, the couple had broken up, and the male had threatened to seek sole custody of their young son, and he was charged with sexual assault. And that's how the matter came before the criminal court and ultimately to the Supreme Court. The issue was whether a person could perform a sexual act on an unconscious person if that person consented to be rendered unconscious for sexual purposes. The majority of the court, of which I was a part, held that consent to sexual activity requires that the complainant be conscious throughout the sexual activity. We said the law requires ongoing conscious consent to ensure that women, or perhaps men, are not the victims of sexual exploitation, and to ensure that a person engaging in sexual activity can always ask the other person to stop. So the male was convicted of sexual assault. The dissenting judges said that while no means no, in this case, the lady had said yes, not no. She had consented to the sexual activity in advance. So a person who consents to transitory unconsciousness will understand that she would be unable to consent or not to specific acts while unconscious. Well, many years ago, the rape law was more forgiving. For a charge of rape to succeed, there had to be evidence of corroboration. Of course, that would often be impossible to find since sexual activity is normally a private matter. But over 30 years ago, that requirement was abolished, and today the law deals with rape more strictly. In J.A., there was a good argument by the accused that it was unfair to say that having consented to being rendered unconscious, that his girlfriend couldn't then say she didn't consent to a particular sexual act while unconscious. But the majority was concerned with sexual exploitation. You can well imagine cases in which there is a lot of drinking. Both the perpetrator and the victim are drunk. Perhaps the victim is in a state of unconsciousness, as in the Turner case, and then the perpetrator goes further than what the victim would have consented to. Well, the point of my telling you this story is not only that it's salacious, but that there were good arguments on both sides as to whether there should be forgiveness. Bona fide consent can be a valid excuse for what otherwise would be a crime. Here, the crime of sexual assault. And if the consent is bona fide and honestly believed by the accused person, and the accused person took reasonable steps to ensure that there was consent, the law will forgive him. Well, so far I've talked about the criminal law and forgiveness, but I'll briefly tell you that forgiveness finds itself in the civil law as well. One of the most obvious examples is bankruptcy. Bankruptcy amounts to the forgiveness of debts. Well, there's an interesting tension, though, in that we tend to think of forgiveness as something we choose to give, but bankruptcy forces creditors to forgive a debtor's debts, kind of a coerced forgiveness. The Federal Divorce Act requires every lawyer who is retained to act in a divorce proceeding to draw to the attention of the spouse the importance of reconciliation and to discuss with the spouse the possibility of reconciliation and to inform the spouse of the marriage counseling or guidance facilities that are available and might be able to assist them in achieving reconciliation. The law does not require forgiveness between the parties, but strives to encourage it. The British Columbia Business Practices and Consumer Protection Act empowers consumers in specified circumstances to cancel certain contracts for goods and services or payday loans, which would otherwise be binding. In this sense, the law forgives consumers who commit to a bad deal and later think better of it. And the law doesn't demand perfection. So in a medical negligence case, a doctor will be held to the standard applicable to his or her level of expertise. A general practitioner will not be held to the same standard as a heart surgeon in the event of a medical negligence claim. So the law will forgive people who make errors. And one other example would be the protection of guarantors. The law recognizes that a guarantor probably receives little or no consideration for providing the guarantee. Therefore, the courts will require absolutely every I to be dotted and every T to be crossed if a guarantee is to be enforced. And if there is the slightest deviation, the court will relieve against that. I want to mention just two more examples of forgiveness. One you'll readily know about, and that is the law of assisted suicide. Up to last year, assisting in suicide was a crime. But the Supreme Court in the Carter decision decided that within narrow bounds, assisting in suicide should not be a crime. And those narrow grounds as set out by the Supreme Court were that the individual had to be a competent adult, that the individual clearly consents to the termination of life, that the individual has a grievous and irremediable medical condition that causes enduring suffering, and that is intolerable to the individual in the circumstances of their condition. Interestingly, not that the individual be terminally ill, which is now a requirement of the law that was ultimately enacted by Parliament in response to the Supreme Court decision. So a person in those circumstances who assists a person to commit suicide will not be found guilty under the law. The law will forgive what would otherwise be a crime. And finally, I'll leave you with a dilemma. You may be aware of a judge by the name of Robin Camp. Justice Camp had been a member of the Alberta Provincial Court, but was appointed to the Federal Court of Canada a couple of years ago. A complaint was lodged against Justice Camp with the Judicial Council, which is the body that governs judges and deals with complaints against judges. The complaint arose from comments Judge Camp had made in September of 2014 during a sexual assault trial in the Provincial Court of Alberta before he had been appointed to the federal court. The accused admitted that he and the complainant had had sex, but he said it had been consensual. While the complainant was testifying, Judge Camp asked her a number of questions, including, why couldn't you just keep your knees together? And why didn't you just sink your bottom down into the basin so he couldn't penetrate you? He asked rhetorically why she allowed the sex to happen if she didn't want it. Ostensibly by accident, he repeatedly referred to the complainant as the accused, including it in his reasons for judgment. Perhaps most controversially, he made these comments. Sex and pain sometimes go together. That's not necessarily a bad thing. I'll grant you that the implication from her is that she wasn't enjoying the pain, but did she ever say, I was feeling horrible? Justice Camp acquitted the accused. The case went to the Alberta Court of Appeal, and it has now ordered a new trial. The complaint that was made to the Judicial Council alleged that Justice Camp, now a judge of the federal court, was unfit to serve as a judge. Justice Camp has since apologized, publicly and repeatedly, describing his comments, his own comments, as unforgivable and disgraceful and appalling. He has said he was ignorant of the law of consent, but has since educated himself. Justice Camp's defense is that he did not intend to treat the complainant as less worthy of belief than the accused, that he applied the law correctly in spite of his insensitive language, and he is committed to improving his knowledge of sexual assault law. He has undergone training at his own expense with a senior Manitoba judge, a psychologist specializing in neurobiology of trauma, and a feminist law professor. Before the Judicial Council, they all testified in his defense. The prosecutor told the Judicial Council that Justice Camp's comments shocked the conscience and shake the confidence of the public. She noted that the mitigating factors of his apology and willingness to educate himself, but questioned how much he had really learned. She noted that earlier in the inquiry, Justice Camp called the complainant fragile, even though she had the courage to participate in her sexual assault trial and the inquiry itself. She said, Justice Camp knew the law, and she said, yet his attitude shone through in a pervasive and glaring manner. If the Judicial Council finds against Justice Camp, it could make a recommendation that Justice Camp be removed from the bench. Ultimately, it would be up to Parliament to actually remove him. If, on the other hand, the Judicial Council accepts his story and is prepared to forgive him, then he will keep his job. I read one article in the National Post by Christy Blatchford that characterized his apology and remorsefulness as the same as every other accused person who has committed a crime. She didn't seem to have much time for these apologies. Of course, she said he wants to save his job. So, should he be forgiven or not? In a criminal context, as I told you, the law recognizes the human condition. When a crime is committed, the accused is punished, but the punishment may be ameliorated on that account. But the law doesn't usually wipe the slate clean. In the context of Justice Camp, it appears that the Judicial Council is faced with a stark choice. Either forgive him and let him keep his job on the grounds that he is rehabilitated, remorseful, and recognizes what he did wrong, or don't forgive him and recommend his removal. One consideration, even having regard to his remorse and rehabilitation, is whether he would have the moral authority to continue as a judge. Would his continuing to be a judge bring the administration of justice into disrepute? This is not going to be an easy decision for the Judicial Council. Well, finally, let me tell you that as a Supreme Court judge, you get to have some quite unique experiences. About 5 years ago, I was invited to judge a moot court between Sir Robin Jacob, then recently retired as a judge of the English Court of Appeal, and Lord Hoffman, recently retired from the then House of Lords. It was a patent case involving a coded stent for insertion in coronary arteries after angioplasty. Before he retired, Lord Hoffman in the House of Lords had reversed the decision of Lord Justice Jacob in the Court of Appeal. The two judges agreed to re-argue the case themselves at University College London, and they asked me to judge it. Both judges are highly respected intellectual property experts. When I received the invitation, I said to Sheila, "Did you ever think in your wildest dreams that I would be judging a moot court between two world icons of intellectual property law?" And she said, "Marshall, you aren't in my wildest dreams." Thank you for your attention.
Justice Rothstein, thank you so much. My only regret is that I now can't use any of those jokes on the High Holy Days because they've all heard them all. But
You may get a different turnout.
I might. Your last dilemma that you placed before us actually fits really lovely into the question that I wanted to pose to you. So Elie Wiesel, Zichron Livracha, may his memory be a blessing, wrote in his essay, The Power of Forgiveness, referring to Jewish law, that in order to be forgiven, one must first admit wrongful action and apologize. And he, of course, was referencing Jewish tradition with regard to tshuva. He references the German government's apology and taking responsibility and request for forgiveness, a formal apology they offered to Israel. And I referenced also in reading it, thinking of the Canadian Truth and Reconciliation Commission and apologies that were offered there. And so I guess the question that I would ask is really twofold. One, and this can go to your own experience as a judge, as a justice, what role does admission of guilt and apology play in the adjudication of justice? What weight do you give that? Should those words, heartfelt as they may be, make a difference in the sentencing? And then a follow-up question, which is when Wiesel continues in his essay and reflects on how he looks at pictures of the lost children from the Shoah, from the Holocaust, and he questions whether or not he can, in fact, forgive the acts that took so many lives and destroyed so many families. When should the law not be forgiving?
Well, let me wade into an area that I met a provincial court judge here a few minutes ago, and he's going to know more about this than I will, but I will say this. Rabbi, you asked me if a person admits his guilt and is remorseful, how should that play into forgiveness? And I think the judicial process is that if a person does plead guilty, in a lot of cases, he's going to receive some consideration for recognizing that he did something wrong, and quite practically for saving the system from having to go through a trial and expend the resources and clog up the courts and cause other people to be waiting in line. And so in cases where people do admit their guilt and express remorse, then I think the law does take that into account, or may take that into account, in ameliorating what would otherwise possibly be a harsher sentence. And then you asked me whether there were cases where the law should not forgive. And in my prepared remarks, I spoke about first and second degree murder. And there are other crimes that have mandatory minimum sentences. So in those kinds of cases, Parliament has seen fit to say, we won't forgive, and will insist on the full scale of punishment because of the nature of those crimes. There's so egregious. I mean, to talk about murder as being egregious is to underplay how serious it is and the difficulty with it. But there are situations where the law will not forgive. And I spoke in the civil context about the Consumer Protection Act, where the law will forgive and let people out of certain kinds of contracts. But it probably isn't going to forgive and let commercial people out of contracts. And so there will be situations in civil cases where you think you made a bad deal, you can't get out. And so the law will look at these circumstances, see them for what they are, and in some cases there will be forgiveness, in some there won't.
So I had one more question before we turn it over to the congregation, and again, it really fits nicely into to your last answer. So in the Jewish view, when we look back through Jewish history and Jewish texts, we really see that the adjudication of justice in Jewish tradition, in Talmudic times, in biblical times, was probably in the frame of restorative justice. That the state, the king, really didn't have agency in the case, and what was of interest was trying to create some form of appropriate compensation for the ox that gored the other man's ox, or the injury that was caused due to negligence or whatever it was. And we can think here even to Talmudic times of an eye for an eye, and the equation of what was the value of that eye to that particular individual and their job or their station in life. But in the law as it is today, and I realize that this has been this way for 1,000 years perhaps, the state now has a role in all of this, that it is not about restoring what has been lost or what had been injured to the victim, but rather, as you said in the example that you just gave, the states need to incarcerate, or the states need to extract some monetary penalty that goes into the coffers of the state and not necessarily to the victim. I guess the question I would ask is, what is the interest and limit of interest of the state in fostering forgiveness between the parties? Do you think that there is a role to be played there? Or is it more as we see it today, that the state's interest is it's the larger public good and not the specific individuals that are involved in the case? And I guess I would just ask one other question, which is, what role should sentencing or law have in repairing the wrong done to the victim?
These are pretty intellectual questions, and I'm not sure that I'm in a position to illuminate very much by way of an answer. I can add perhaps one or two things. In some provinces, and I believe that there are victim compensation arrangements whereby a victim may be compensated for the wrong done to him by a perpetrator. But frankly, I can't go much further than that because I don't know any more about victim compensation, but I vaguely know that I think it exists, and I'm sure is inadequate, but something along those lines exists. Perhaps somebody in the audience will know better. You spoke about the role of the state in perhaps reconciling people. Again, I'm venturing into an area that I don't, that I'm not so comfortable with. My initial reaction is that that's not the role of the state. It may be the role as between the victim and the perpetrator, and there may be situations where a perpetrator and a victim have a relationship, either a family relationship or a friendship of some sort, where reconciliation is important and where it may take place. And I'm just recalling that there may be cases, there are cases where a wife accuses her husband of some kind of assault or something like that, and then they go to prosecute, and the wife wants to recant, and so things like that can occur. But I'm not sure that the state has a role in that kind of reconciliation. The one example that I gave about the divorce laws, whereby a lawyer has to tell his client about the availability of reconciliation, recommend it if it's at all possible, is an area where the state, in enacting that law, is trying to encourage reconciliation. But the state as an actual functionary, it doesn't offhand seem to me that the state is in that role. But I stand to be corrected if somebody knows better.
Thank you, Justice. So I want to invite anyone who has questions for the Justice to come on up and ask a question. I know it's always hard to get the first question, but I asked the first two, so really, you're like the third or fourth at this point. Thank you, Joel. Always kind of.
Thank you for just entertaining and also engaging discussion. You talked a couple times, like the example of Justice Kampf, about you talked about shocking the public sense of consciousness, and that suggests that maybe these issues are relative to cultural norms that change over time. And I'm interested whether you think there are universal truths that transcend time and evolution of culture and politics.
Why did I agree to take questions? This is hard stuff. Come on. I'm not sure I'm answering your question, but I mean, a universal truth, if you look at murder, for example, I think that it's universally recognized that murder has to be punished. And but some things do change. In Canada, we had capital punishment until the or at least it was available until the mid-1970s, although I think the last capital punishment occurred in the early 60s. Today we don't. In the United States, they have capital punishment. So the nature of punishment is not a universal truth or a universal way that people look at things, but for certain, the fact that murder is a crime is definitely a universal truth, if I can put it that way. I'm not sure I'm exactly answering your question, but that's the way I perceive the kind of thing you're asking.
Jeff.
Thank you, Justice, for being here. Around this time of year, at the high holidays, we not only ask God for forgiveness, but it's not really complete until we ask for forgiveness for those we've harmed. In your experiences, what, law aside, what have you seen to be the impact of people asking for forgiveness to their victims?
Well, I believe that in the criminal courts, there can be pre-sentence reports of the accused and victim impact statements of the victim. And so those victim impact statements, sometimes, as in the Turner case, were pretty harsh and didn't accept that he had been remorseful or apologized or anything like that. But in some cases, those victim impact statements will say, well, we've reconciled, and I'm asking the court to provide a more lenient sentence than might otherwise be provided. So in that sense, there is some way that the victim and the perpetrator can kind of attempt to reconcile their situations. There's so many different situations in criminal law. Some amongst people who are friends or relatives, in which case probably that kind of reconciliation is more likely. Then there's the stranger case where it's likely less so. But I think there are situations where between impact statements and things like that there can be some move in that direction.
And would it be your personal opinion that it's a good idea to keep it in our Jewish tradition of asking individuals for forgiveness for those we've harmed or wronged, just on a personal level?
Well, yes. If I've understood what you said, I think so. You're saying, is it a good idea?
Is it a good thing? Do you think there's actual benefit that comes from it? Is it?
Sorry, is there benefit to?
To those we've wronged, to the victim? Is there?
Well, sure.
A sense of,
sure. If you've done something to someone and you recognize that you've done it and it was wrong, I think it's cathartic to you to apologize to them, and they will get some satisfaction out of recognizing that you know you've done something wrong. So yes, I endorse that. I think that's right, and I think that all people should govern themselves that way. Unfortunately, it doesn't happen a lot.
Thank you very much.
Thank you, and I'd like to ask the question about what is the impact of the state having imposed an increased number of mandatory minimum sentencing laws with regard to a justice's ability to consider forgiveness?
Well, where Parliament enacts mandatory minimums, Parliament is saying no forgiveness. The offense is so egregious, or that society needs a protection of sorts, and therefore a sentence, there should be a mandatory minimum sentence. And the Supreme Court, in one case, did strike down a mandatory minimum sentence that was overbroad. It went too far. But it's a question of what society wants. You know, when they look at different crimes, it may, as in the Turner case that I recounted, when the judge let this individual off with a 6-month sentence for rape, public outcry was so great the legislatures came in and said they wanted a mandatory minimum for that particular kind of rape. So it's what society is looking for: retribution. They're looking for protection. And it does take away the judge's discretion. There's no doubt about that. You know, once you've got a statutory mandatory minimum, the judge cannot go below that. And it does, and judges have complained about that, and a lot of people have complained about that. But it doesn't necessarily mean that the mandatory minimums are wrong in all cases. I mean, I haven't heard a lot of complaints saying that first-degree murder shouldn't have a mandatory minimum of 25 years. And so, but then you'll get some squishy kind of offenses where there might not be violence involved. It may involve the possession of an improper weapon, of a restricted weapon that you're not allowed to have. Well, there's no violence involved, but there's potential. I mean, if you got a sawed-off shotgun, you may not have used it, but why do you have the sawed-off shotgun? And, arguably, a mandatory minimum sentence might be appropriate, even though there's no violence immediately involved. But maybe I'm just rambling. It just seems to me that there are a variety of circumstances, some of which will justify a mandatory minimum, some not.
Thank you.
I also want to thank you for your talk. I have the flip side of that question. Parliament has changed things like minimum mandatory sentences and has changed laws over the years and will continue to do so. But my question is, what's the role or the effect of religion in those changes? And I use the abortion laws as a very good example where things changed completely, but it was a very long fight. What role do religions play in changing the laws imposed by Parliament on the courts? In a nutshell.
What religion? Well, we know, for example, that Roman Catholics do not believe in abortion. I believe that Orthodox Jews do not believe in abortion. And so there will be a segment of society that would view certain kinds of crimes in certain ways. Same thing about assisted suicide. I think that there are perhaps certain religions or certain segments of religions that may be opposed to assisted suicide, and so that could have a play. On the other hand, sometimes religion is very personal. I mean, whether there's a law against abortion or not, if you feel for religious reasons or for personal reasons that you don't want to participate in that kind of thing, either as an individual, patient, or as a doctor, you don't have to. And the same thing with assisted suicide. It's up to you personally, for your own personal reasons that may be affected by your views of religion, to participate in that or not. But in terms of religion, I'm just trying to place what kinds of laws we might have, criminal laws we might have, that might be affected by religion as such. And the two that do come to mind are assisted suicide and abortion. I'm not going to polygamy. That's a very hard question these days, anyway.
Thank you very much, Justice. I have a couple of questions, and they're pretty easy and they're really hard at the same time, because they're asking for your personal opinion rather than the legal opinion behind it. So I remember back in my childhood when they shifted the judicial process and said incarceration was not about punishment, but about rehabilitation. So the first question is, do you think in the past 25 years we've done a good job of that, and whether the court system really works to rehabilitate people? And the second one would be your personal opinion on something you brought up earlier on the basis of forgiveness, that children under the age of 12 are automatically forgiven. If I go back again 20 years, or 25 years. Children 25 years ago are not the same as they are today. They are much more in touch with the world, much more connected internationally through the devices in their hands. Their knowledge of right and wrong is vastly different. Do you think the court or the judicial or the legislators have made a wise decision in not catching up with the fact that children at any age in this day may be responsible and knowledgeable about the crimes they commit? So I'm just looking for your opinion so we don't have to delve into the jurisprudence of it. Thank you.
Well, you've asked me about my views of whether incarceration has been doing its job in terms of rehabilitation, and I would say I hear stories that in jail people become drug addicts for a variety of reasons. They join gangs and all that kind of thing. But because those things happen doesn't mean that we got to abolish jails. And so it's difficult. I mean, I suppose if we had unlimited resources, we could improve the jails and have more counseling and have more separation of people and do other things that might make the incarceration process more beneficial for society and for the individual. But resources are limited, and frankly, people who go to jail aren't a terribly sympathetic segment of society, so you're not going to get a lot of people wanting to throw a lot of dollars in those areas. So I know that there are problems in the jails and that there are difficulties there, but in addition to rehabilitation, there's the question of protection of society, and there's a variety of issues with punishment, one of which you can't deny is retribution. As in that Turner case that I recounted, the California case, there's a real outcry for the fact that this individual was let out too soon, according to public opinion. So there are a variety of things that go along with incarceration you've got to take into account. It's by no means perfect, but hopefully as society moves on and as resources are available, the experience there will become more optimum. With regard to children and the age of 12, I'll tell you what my own view is, but it's just a personal view, and that is that when you set up arbitrary rules, like 12 years of age, you're not taking account of the individual circumstances. There might be a child who is younger than 12 who does understand what he's done and the wrongfulness of what he's done. There might be a child of 13 who doesn't. So whenever you set up an arbitrary age like that, you're gonna make some mistakes. I told you in my remarks that these ages for young people being absolved vary from 7 to 15 in different countries. So all kinds of people have different ideas of what the appropriate age is. And I think my own view is that I probably would have preferred the older system, whereby there's a presumption that the children under, say, 12 do not appreciate the consequences of what they've done, don't understand the wrongfulness of what they've done. But the Crown, the prosecutor, should be able to overcome that presumption with evidence. And if there is such evidence, as you point out, today children are much more knowledgeable than they were many years ago, then that possibly would be a better way of handling those situations.
I think we have time for just one or two more questions if there's still another one.
Last question. I was wondering if you and Sheila have considered a second career as a stand-up comedy team.
I would, but she keeps telling me that I need to get new material.
Are there any other questions for Justice? Justice Rothstein, I want to thank you, and on behalf of our whole congregation, you and Sheila, for spending this evening with us. Thank you so much. Remember, those are hard questions. That's why I never let them ask questions when I was listening. I was just saying to the judge, those were hard questions. That's why I don't let them ask questions after I give a sermon. Just a little bit of a commercial for what's going on the rest of this evening and beyond. So we'll adjourn to our social hall. We have a lovely reception, an oneg, I guess we could say, though the service hasn't happened yet. We call it a pre-neg, I guess, in our social hall. Our service will begin at 10 o'clock. For those that have never been to a Selichot service, it really is beautiful. I know that the hour is late, though we made it earlier this year. We changed the covers of our Torah scrolls, the mantles of our Torah scrolls. We changed the melodies of our services. Rabbi Brown and Cantor Tausik and I will lead and begin with Havdalah. It's really a beautiful service. We'll be out by 11:15. So I hope that you'll stay. And if not, then I hope at least you'll enjoy some refreshments, and we'll reconvene at 10 o'clock.